Good morning. Today's video, I'll be talking about concurrent filing of Form I-485, and I'll be talking about the latest in immigration news. This one is not really new, but it happened, I guess, last week, by the end of last week. So this is about waiving some interviews, and then we talk about this BBB, where we currently stand. My name is Bijoux Ngwanda. For those who do not know me, I'm an immigration lawyer here in DC. I am born in Kentucky and the District of Columbia. We do work complex immigration cases across the country and around the world. If you need a consultation, again, you can call my office. The phone number is 202-751-2180. Consultation fees apply as usual. Email as well is on display. So if you need a consultation on your case, please don't hesitate to call my office so that we can schedule you for a consultation. But let's get right into it. Concurrent filing, because a lot of people have been asking me about this. Well, can I file my Form I-130 with I-485? Can I file I-140 with I-485 at the same time, concurrently? Well, the answer is yes and no. It just depends on whether the visa is immediately available or not. So let's get right into it. Let me share my screen with you because we're just going to be using those USCIS web pages. That's where most of the informations are. So let me share my screen with you for a moment here, and then you'll see what's going on here. Okay, concurrent filing of Form I-485. So you can, in fact, file concurrently with the Form I-485 if it is filed prior to the approval of underlying immigration visa petition. But concurrently, to be considered, that you are filing concurrently, for that form to be considered at the same time, well, what has to be happen? What can basically, who is qualified, right? What type of petition qualify in terms of concurrent filing? Okay. Well, who can file concurrently? That's the question. We allow concurrent filing for immediate relative of your citizen living in the United States. You see the word living in the United States. So, I-130 petition. When it comes to parent, right? Immediate relative, we're talking parent, children under the age of 21, and we're talking spouses. While you can file concurrently, whether you have an I-130 approved in advance or not, you can file concurrently. It's especially for spouses. I like it to file concurrently because at that point we can file with the I-1 765 so that you can get your work permit and travel document I-131, so that when the case is pending and you're adjusting status, in the meantime, 6 months or 7 months later, you might get your work permit, travel document, and you can move around while they're still adjusting case, adjudicate your case. So it is beneficial to file concurrently, especially for spouses. That's what I like to do most of the time. Okay. Most employment-based applicant and their eligibility family member, when a visa is immediately available, that's when you can file concurrently. Special immigrant juvenile, if an EB4 visa number is immediately available and we have jurisdiction over the application to adjust status. Okay. Self-petitioning battered spouse of child, that's a VAWA petition, right? The abused spouse or parent of a U.S. citizen, or if an immigrant visa is immediately available. VAWA petition too, when you file the Form I-130, you can file with I-485, I-765, because the visa is considered to be immediately available because you're filing under immediate family, immediate relatives, right? So And it is best to file that way too, because remember with VAWA, when you're filing the form I-130, well, in order for you to get the work permit, you have to wait until the I-130 get approved, which can take at least 20 months. But if you file together with I-130, I-485, I-765, then, well, down the road, you might get the work permit prior to them adjudicating the petition, because now you're getting it under C9, right? So what else can you consular processing and concurrent filing. Concurrent filing cannot occur in consular processing cases. That's what it says. If the relative lives in the United States, as the immigrant petition is filed with USCIS, the application for an immigrant visa is filed with the Department of State. Therefore, concurrent filing is only seen in the context of an immigrant who's adjusting status while in the United States. That's the word. Remember at the beginning, I say here, living in the United States. So that's when you are able to file concurrently, and the visa has to be immediately available. Okay. And here they're talking about visa availability and concurrent filing. You might file your petition and application concurrently when there is a visa number immediately available at the time of filing. Concurrent filing is always allowed for all immediate relatives of the United States citizens, since there are no numeric limitation in category. Okay, so immediate relative, parent, child, spouses, because there's no limit on the availability of the visa. But when we come to children over the age of 21, then the visa is not immediately available. Therefore, you cannot file concurrently, because now you have to wait for priority date and stuff like that. So, and then even if there's a visa number available at the time of filing, you might not be allowed to file concurrently unless you have an approved basis of eligibility. So before being allowed to file adjustment of status. So for more information, you can check the form I-130, I-140, I-360. And I-140, really, when you file concurrently, well, that's like employment type of visa. But when it comes to certain type of employment, the visa is not immediately available. When we talk about religious workers, because they have to wait on the line, then you cannot file concurrently, even if it's using the form I-360. So it just depends on what type of employment-based petition that you are actually filing for you to be able to file concurrently. Okay. And again, we go back to the question of adjusting status, my friend. When it comes to adjustment of status, right? When you're filing adjustment of status, really, it has a lot to do with admissibility. So that's when they check whether you are admissible in the U.S. Okay, whether you were inspected at the port of entry or parole, lawfully present at the time you're adjusting status, no criminal records, or no other inadmissibility issues under section those other sections of the Immigration and Nationality Act. So those are the steps to check when you're adjusting status. Of course, with spouses petitions, while unlawful presence type of is actually waived because you're marrying a U.S. citizen. Those are some, and then in the case of VAWA, that too, unlawful presence is also waived. Okay. So, and then you can go ahead and actually look into those again. If you have more questions, please, if you really need a consultation, please, 202-751-2180. That's the phone number you call. Consultation fees apply. And let's talk about this waiver. Waiver of personal appearance and in-person oath requirement for certain immigrant visa applications due to COVID-19. While they're waiving interviews for certain immigrant petitions, okay? the Department of State is waiving those interviews. So basically, this temporary rule provides flexibility for consular officers to waive the personal appearance of certain repeat immigrant visa applicants who were approved for an immigrant visa in the same classification and on the same basis as the current application, or after August 4, 2019. So because of the backlog, one of the solutions that they're coming with is to waive interviews, like in-person appearances. Okay, if you have an approved immigrant petition, for example, if you, let's say you have an approved I-730, right? That's the refugee or asylum petition. Like the petitioner here has been granted asylum, and then they file I-730 for you to actually get here, or the beneficiary to get here. So those are the type of what they call immigrant visa. Or I-130 has been approved immigrant visa as well. So while they're trying to waive those in-person interviews so that they can process those applications as soon as possible and give those people the visa, because COVID has made it so difficult for those a lot of people to get interviews. Okay, so, and when is it effective? It start immediately effective December 13, 2021 to December 13, 2023, at least 2 years, right? So if you have a lot of questions regarding that, well, you can call my office, you can email. But remember, when you email, consultation fees apply as usual. So, but you can go ahead and look at the Department of State. You will see, and if you have an immigrant visa petition approved, you can request that the consulate really just process your case, because case by case basis, of course, but they're waiving certain interviews. Okay, I'm gonna stop sharing here. I'll come back here. So what's going on with the immigration bill? My friend, what's going on is that, well, this week, everybody, they're going to debate. They have actually drafted the final test, and they're going to submit it to the parliamentarian. And then next week, every side, the Democrat and the Republican, everybody's going to argue their case, make their case, and then it's going to go to the floor for the vote. So we're still waiting. Chuck Schumer has said that they want to make sure that by the end of before Christmas, of course, we have something, right? So the president can sign it and into law. But is it possible? That remains to be seen. Really, on this channel, I'm not going to tell you, well, it's impossible or it's possible. We just have to wait and see how it's going to turn out. If you have questions, comment below. I know yesterday a lot of people asked questions about designated Schedule A type of applicant. We talked about it. We talked about you have to be either a therapist or a nurse or a person with special ability as defined. Well, the definition is right there. If you want to find out, then you need a consultation, and you have to have an offer from the employer. You can't just apply on your own. So we kind of explain that. So again, thank you for watching. Please comment below, share, like. Don't forget to subscribe. Really, you do not have to forget to subscribe. And don't forget to actually go to my channel. Let me share again the screen with you with here, because you have to go to my channel and try to buy a gift for your loved one. Okay. If you go to my channel here, okay, you click on any or interested in video. You look at the buy Bijoux Ngwanda merchandise. Okay, you shop on one, and if you go here, for example, this is it goes straight to my store. Oh, it's taking some time to load. Not sure why. But anyway, it goes straight to my store. Let me go back. It goes straight to my store here. That's where you buy. And it has payment plan as well. It's just taking some time to load up. I'm not sure why. I'm gonna stop sharing for now, but anyway, that's how you go to buy. So don't forget to comment below. Let me know what you think. We are still going to do a lot of employment, at least tomorrow again, and tomorrow is Thursday, right? Tomorrow again, and then we're going to do Friday again, employment based type of videos, so that you can get some type of understanding. If you have a sponsor, how is it going to play out? And when it comes to adjustment of status, how is it going to play out? Until next time, again, bye-bye.